So the crimes that are being assessed, and right now there's a lot of people, including the International Criminal Court, that has opened an investigation. The U.S. government has a big team as well, working on gathering information about these crimes. But these are the crime. These are the violations. Violations of the Geneva Conventions, violations of the Hague Conventions, customary international law. Customary international law I'll get into, but that you should consider the general standards that every nation considers to be the law of armed conflict. Violation of the UN Charter, the crime of aggression. This is a big one. So we will discuss that one probably the most. The Geneva Convention. Okay, so the Geneva Convention was signed by, just move. Oh, sorry. The Geneva Convention was signed by the Soviet Union in 1949. Oh my God. I'm trying to move that because I can't see the top of my presentation, but the additional protocol 1 to the 1949 Geneva Convention was ratified by the Soviet Union Supreme Council in 1989. In October 14th, 2019, the UN recognized Russia's violation of the Geneva Conventions in Crimea. On November 2019, what Russia withdrew from additional protocol to the Geneva Conventions on the protection of victims of international armed conflict. The law recalls the statement made by the USSR upon ratification of the additional protocol in 1949 concerning the protection of victims of international armed conflict. So once the UN stated that the attacks in Crimea were a violation of the Geneva Convention, Russia responded by withdrawing from the protocols that protect victims of international armed conflict. Some are saying this was a precursor and they knew what is happening now was going to happen. I don't know if that's true or not, but this is definitely was their attempt at this point to start moving away from the Geneva Convention. The Russian Federation withdrew from its obligation to protect, assist the wounded and sick, both military and civilian, regardless of which party they belong to. So they didn't withdraw from the entire Geneva Convention, just this protocol, regardless of which party they belong to prevent attacks on medical units, personnel, to ensure the protection of civilian population. So they've withdrawn from that protection of the Geneva Convention. The clergy, so priests, rabbis, as well as other persons under the protection of the convention. Russia does not recognize the article of the additional protocol to the convention, which enshrines the UN Special Commission as a judicial body, which has the right to judge the state for violating the rights of civilians in war. So this all was triggered by the claims by the UN Special Commission that Russia was violating the Geneva Convention, and so now they've also withdrawn all recognition of the UN Special Commission. And Ukraine ratified ratified the Geneva Convention as part of the USSR. That transferred to them as when they became an independent country, and they have not withdrawn in any form or any part of the Geneva Convention. So what are these protections? Article 51, the protection of victims of international armed conflict. The civilian population enjoys general protection against danger arising from hostilities and must not be attacked. Never are civilians to be directly the focus of a military operation. Attacks on non-military facilities are expressly prohibited. This article concerns civilian objects, all objects which are not military objectives, stating that such objects cannot be attacked. Having worked on the war crimes in the former Yugoslavia, when a civilian object is used, for example, if there was a case in Mostar where the bridge had enormous historical and was considered a historical landmark. If it was being used for military purposes, it could not be protected. If a school, if there are no children in that school, the children have all been removed and it is now being filled with munitions, then that is a violation by the parties on the ground, by the parties who are being attacked, and the party attacking the building is not liable. So if a civilian object is being used for military purposes, this obligation disappears. But if it is an apartment building, a home, a maternity hospital, that is a clear violation of the Geneva Convention. Persons taking no active part in the hostilities must be treated humanely without any adverse distinction. So if you occupy an area militarily, you cannot start treating those individuals. You cannot start imprisoning them, treating them badly. Those civilians have to be treated as if this is completely humanely and allowed to basically live their lives. This prohibits taking any measure to cause physical suffering or extermination. Civilian hospitals organized to give care to the wounded and sick, the infirm, and maternity may in no circumstances be the object of the attack, but shall at all times be respected and protected by the parties to the conflict. Use of weapons that cause superfluous injury or unnecessary suffering, as well as means of warfare that cause widespread, long-term, and severe damage to the natural environment are prohibited. There is discussion of thermobatic weaponry, which are these, and I can pull it up because I have a slide that I used in a different presentation. These are enormous sort of, let's say, cannons in a historical way with hundreds of places that shoot out. It doesn't just attack the individual. Let's say it's attacking a military arsenal. It doesn't just hit the military arsenal. It will hit miles beyond that. Same thing with chemical weapons. Anything that causes greater damage and affects widespread damage and affects greater number of civilians and population is prohibited. Article 51 through 54 of the Geneva Convention outlaws indiscriminate attacks on civilian populations and destruction of food, water, and other materials needed for survival. There is information, of course, coming out that their food, there is now the situations of distress in terms of food and water in certain regions. Starvation as warfare is prohibited. I worked on a case, again, it was in Mostar. It was the Croatians sealing off the Muslim population and the Muslim population going towards starvation. They were able to charge the Croatian army, the Bosnian Croatian army with that for starvation. Hostility against places of worship or cultural significance is prohibited in accord with the Hague Convention. We will get to that now. The Hague Convention is very important in terms of protecting churches, museums, theaters. Dams, dikes, nuclear stations may not under any circumstance be attacked. The Hague Convention. The Hague Convention was drafted in 1899 and 1907, and it lays the foundations of laws and customs of war. The Hague Convention was brought together and created by a Russian count in 1899 and 1907 by the Russian Tsar. So this was all a movement by the Russian that brought together all of Europe to sign this. The Hague Convention of 1954 establishes laws protecting cultural property during armed conflict. The organization UNESCO was formed out of this, out of the Hague Convention. Both Russia and Ukraine are signatories. Article 5, concerning occupation. This is the Hague Convention of 1954 that deals with cultural property. Any high contracting party in occupation of the whole or part of the territory of another high contracting party shall, as far as possible, support the competent national authorities in safeguarding and preserving its cultural property. Should it prove necessary to take measures to preserve cultural property and in occupied territory and damaged by military operations, and should the competent national authorities be unable to take such measures, the occupying power shall, as far as possible and in close cooperation with such authorities, take the most necessary measures of preservation. Any high contracting party whose government is considered their legitimate government by members of resistance government movement shall, if possible, draw their attention to the obligation to comply with these provisions of the convention dealing with respect for cultural property. Cultural property is consistently attacked. It was prosecuted. The attacks on Jewish cultural property were prosecuted at Nuremberg. The attack on cultural property was prosecuted in Bosnia. The Serbian and Croatian armies both attacked Muslim Jami places of worship. In Croatia, the historic city of Dubrovnik was shelled, and it was a UNESCO proper protected cultural monument that was shelled. And at the time, UNESCO was on the ground, so they created a system to monitor all of the damage to that property. In Syria, NATO was monitoring. I worked with a group from NATO and UNESCO to create a training manual so that NATO forces would be able to identify what the cultural property is. Cultural property destruction was prosecuted at the International Criminal Court in the situation of Mali in Africa. And UNESCO has noted that in the conflict between Azerbaijan and Armenia, Armenian cultural property was attacked, and the attacks were directed towards destroying Armenian churches, very old Armenian churches and places of worship. Customary international law. It's a very broad idea, and customary law itself is a legal concept that if you're not a lawyer, you might not understand, but it's just basically a general understanding by everyone that this is wrong, that this is a violation. And how do they know that generally? Most states, most countries will have specific laws dealing with that issue. There'll be treaties dealing with that issue, and there'll be a history of addressing things as that issue. So at all points under customary international law, especially the Soviet Union being one of the main founders of Nuremberg, of the Geneva Convention, under customary international law, they would have been aware of what is a violation of international law. So a general and consistent practice of states followed by them from a sense of legal obligation. So whether you're a signatory to that document or not, if this has been a part of your that you're aware of, and that you're signed treaties that agree with that, and you've had in your national law, and you have been involved with this there's a historical tie to that, then you fall under customary international law. That means all or nearly all nations consistently follow the practice in question, and they must do so because they believe themselves legally bound. And that's a concept referred to as opinio juris, sive necessitatis. So a legal opinion of necessity. Some particularly prevalent rules of customary law can acquire the status of jus cogens, which means norms. They become absolutely normal because everybody knows that genocide is wrong. Everybody has within their legal history something that identifies that, so that there can be no derogation from that. Every state that has signed international treaties, that has been part of the United Nations, that is part of different international courts, knows that there's a prohibition against slavery or genocide. So for a particular area of customary international law to constitute jus cogens norms, state practice must be extensive and virtually uniform. So in these two cases of slavery and genocide, it is. Crime of aggression. This is very controversial one, and this is a very big deal concerning this current conflict. The crime of aggression was only prosecuted at Nuremberg. It originates from Nuremberg. It was never prosecuted in the former Yugoslavia, because in the former Yugoslavia, it wasn't only until later that these were recognized as different states. It was originally treated as if it was a civil war. It is prohibited against the Charter of the United Nations, Article 2, Section 4, which, of course, Russia and Ukraine are both signatories to. It prohibits the threat or use of force against the territorial integrity or political independence of any state. Two exceptions were made. Firstly, individual or collective self defense by states involving the use of force is authorized by Article 51. So, self defense. This use of force, the second exception is the use of force authorized by the UN Security Council. So, if you'll remember when the US wanted to do the operation in Iraq, they went to the Security Council to get permission to do that. They didn't present everything legally, but that's how you do it. You have to go to the Security Council under Article 42 of the UN Charter and say there's an essential need for a country or for a group of countries to get militarily involved. General Assembly Resolution 3314, 1974, defines aggression. So this concept was created in the UN Charter in the 40s. It becomes much more defined and focused in 1974. It's aggression as the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations as set out in this definition. Article 3 defines what are aggressive acts: invasion or attack by the armed forces of a state or territory, bombardment by the armed forces of the state or territory of another state, the act of a state allowing its territory to be used by another state for committing an act of aggression against a third state. So hypothetically, if the state near Russia allowed itself to be used, that state becomes as culpable as the original state, sort of like a conspiracy theory in individual liability. And the sending of armed bands or mercenaries by the state to commit acts of armed forces against that state is also considered an aggressive act. The crime of aggression grew when it came time in 2010 to the establishment of the International Criminal Court. It stated in Article 5 of its establishing document, the ICC has jurisdiction over the crime of aggression. However, the second paragraph of Article 5 sets out this jurisdiction can only be exercised once a provision is adopted defining the crime and setting out the conditions under which such jurisdiction shall be exercised. So they knew when they set up the ICC that they wanted the crime of aggression, but they didn't yet know exactly how they wanted to define it. They went on to create an amendment, Article 8, which states the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an action or aggression which by its character, gravity, and scale constitutes a manifest violation of the Charter of the United Nations. ICC can only charge the crime of aggression against a signatory to the Rome Statute. So the United States, Russia, China, all of the countries that have not signatories to the ICC's Rome Statute can never be charged with a crime of aggression. So it's not possible to charge this against Russia.